Take an historical look at how civil rights have been handled in the United States. And we can basically split this into three periods. The first being from the 1600s to 1865, which is, of course, the end of the Civil War. The second period being from the end of the Civil War until 1954. And the third period being from 1954 to the present. The first real clear statement of civil rights in this country is Dred Scott v. Sanford. This is an 1857 case where a slave has left the South and gone to a northern state. Can't remember if it's Minnesota or Wisconsin. It doesn't really matter. Where slavery was illegal. And then he returns to the South, and years later his owner dies, and he declares that he is free. And he says that when he left the South and went to the northern state, he became a free man because slavery was illegal up there. And then he claims that he returned to the South and served his master willingly as a free man until his master died, and now he's free. Now this goes to the Supreme Court, and the Supreme Court has a real problem because it's a heavily Southern and really racist Supreme Court led by Roger Taney, who does not want to rule that this guy is free. And so to avoid having to rule on the case, they throw the case out. And they declare that he is chattel and he has no rights under a white man's government. He also goes on to say in this non-decision that the Missouri Compromise was completely invalid and the federal government had no right to ban slavery anywhere and that slavery was legal everywhere. And so even if Scott could have had his case heard, he would have lost because the federal government couldn't tell Minnesota or Wisconsin or any other state that they couldn't have slavery. This is actually one of the things that leads to the Civil War. The North gets very shocked by this complete rejection of African American rights. And this is one of the stepping stones on the way. Of course, the Civil War is fought, at least in part, over slavery. And the North wins. South loses. And so we get the 13th Amendment, which outlaws slavery. You can pause and look at this chart now, or you can look at it in your book. But this is what I'm going through anyway. We get the 14th Amendment and the 15th Amendment, which we'll talk more about a little bit later. As I mentioned before, the 13th, 14th, and 15th Amendments are largely ignored. Slavery doesn't come back, but systems that replicate it come back. States certainly don't guarantee equal rights for their citizens, as we see in Jim Crow laws, or laws that treat African Americans different under the law. So something might be legal for a white person, but illegal for a black person. And it creates a separate status, or a second-class citizenship for blacks. Now, of course, lawsuits will come out of this, and the most famous is Plessy v. Ferguson, which is an 1896 case where a man who's only like an 8th or a 16th black, I mean, he's almost all white, but any black was black, but he was forced to ride on the black train car, the segregated train car, and he sued over this, and he said that this was not giving equal protection under the law as the 14th Amendment required, regardless of race. And in this case, again, a very conservative racist Supreme Court ruled that separate but equal was okay. So as long as there was a black car and a white car, that was equal protection. It didn't matter if the black car was infinitely inferior to the white car. As long as they both had a car, that was fine. And so we get the drinking fountains and the bathrooms and the restaurant segregation and all these sorts of things. You can pause here if you want for a minute. And there you see the drinking fountains. Now, in 1954, Plessy is going to be overturned. In the Brown v. Board of Education case, which I think you're all familiar with, this says that schools must desegregate right away, and that separate but equal is inherently unequal. And they actually rule that even if the schools were exactly identical and the quality of the teachers is identical, it would still be unequal because they rule on the idea that there is a psychological impact to being told that you are different and you have to go somewhere else. And that was actually more critical to their ruling than the actual condition of the schools. Is the idea that raising a race of people and telling them that they are second-class or inferior citizens was inherently damaging regardless of what sort of facilities you provided. This will lead to all kinds of battles over school districts trying to avoid segregating. And one of the ways they try to avoid segregating is simply by creating new school districts that don't have any black people in them. If there's no black people in your school district, you can't integrate. This is, by the way, where Westlake comes from, here in Austin. The Eanes Independent School District is one of what are called white flight school districts. These are school districts that were carved out of cities in parts of town that were all white or overwhelmingly white, so they could avoid integrating. This is called de facto segregation. So you say, we're complying with the law, but there's no black people to put in the classes, so, oh well. So they were desegregated de jure by law. Black kids were allowed to go to the white school. But de facto, in reality, they remained segregated because they simply drew school districts with no black kids in them. Another way to do this was the concept of neighborhood schools, where you put a school in the middle of a neighborhood and say, well, all the local kids will go there. Well, in most cities, particularly back in the 60s and 70s, all the white kids lived in one part of town and all the black kids lived in another part of town, so this created segregation naturally. The pivotal moment, really, more so than Brown, and as important as Brown is, because Brown, of course, was largely unenforced, is the Civil Rights Act of 1964. And this made racial discrimination illegal not only from the federal government, which actually had happened under FDR and then under Truman in steps, but now even private businesses cannot legally discriminate. Of course, was a whole new level of government involvement in this issue and became a really hot topic in the 1960s. In fact, one of the big issues in the 1964 and again in the 1968 presidential campaigns was this notion, can the government tell a private business to discriminate? And we had a really interesting conversation about freedom here, where you had, for example, in 1964, the Republican candidate Barry Goldwater would use the word freedom to say you should, even though he said he was not a bigot and he didn't support bigotry, that Americans had to be free to be bigots. That was his idea of freedom. And then you had LBJ, of course, who signed the Civil Rights Act on the Democratic side, saying black people have a right to be treated equally in our society, even if they're going to a hotel or a restaurant. And that was his idea of freedom. So it's interesting how that word freedom can, in this case, mean the exact opposite things. It also forbid employment discrimination. Of course, it tied federal school funds to desegregating the schools, which is how Brown finally gets enforced. Creates an Equal Employment Opportunity Commission. If you've ever applied for a job, you've probably seen that on the application. And it strengthened voting rights legislation. Of course, it'll take the Voting Rights Act of 1965 to really strengthen voting legislation, though. You see here a chart where you see a percentage of black students in the South who have white kids in their school, and you can see the dramatic change that happens really just in the years from 1964 to 1970 or so. And now today, of course, almost all black students have at least a white kid in their school. Now, let's talk about the right to vote. Suffrage, of course, means the legal right to vote. The 15th Amendment extended suffrage to African Americans. Although not Native Americans, I should point out, we still weren't interested in them voting. At the time, there were poll taxes, which was a small tax. When I say small, I mean if you had any money, it was inconsequential. If you were incredibly poor and lived in extreme poverty, it was crippling and you were unable to pay it. And the idea of it was to keep poor people from paying, and since minorities were overwhelmingly poor, it essentially amounted to a racist attempt to not allow blacks to vote. The poll we also had the all-white primary. And this is where you said, well, anybody can vote in the general election, but when the parties are choosing their nominees, only white people can vote. Well, by definition, then you're only going to get white candidates, right? Because the white people at that time were not going to choose a black candidate. Luckily, that's changed. But this was just a way of controlling the electoral process. This was overturned in the Sweat v. Painter decision of no, that's not Sweat v. Painter. This was overturned in Smith v. Allwright in 1944. Yeah, there we go. The 24th Amendment eliminated poll taxes for federal elections, and they've since been eliminated for, that's been applied by the Supreme Court to state and local elections in Harper v. Virginia State Board of Elections, 1966.